A very good evening to our respected Professor in charge, Professor Dr. Sarbjit Kaur, our resource persons, our enthusiastic students, and my worthy colleagues. I, Shivika Choudhary, Assistant Professor at Law Center 1 Faculty of Law, University of Delhi, and in my capacity as the Program Director, welcome you all to the webinar on subject orientation for overview of optional subjects for LLB fifth term. It is a kind request to all the students that please log in from your due email for technical compliance so that you can log in automatically. Secondly, very important, to ensure a noise-free dissemination of this webinar, the participants are requested to kindly mute the microphone while the presenter is speaking. Thirdly, please post your questions in the chat box anytime during this session to be addressed by the presenter or in the question answer round. And lastly, the recorded version of the webinar would be made available on the YouTube channel of Law Center 1. I feel honored to extend a very warm welcome to all of you. At this stage or at this juncture where you find yourself students, as in when you're about to enter the fifth term of LLB, the students may be faced with many questions, with subject option to choose, how will it help in their career goals, how would the student feel interested in studying the subject. To answer to all these conundrums, the Law Center 1 has organized today's webinar, and a very hearty welcome to you all. I find immense pleasure in welcoming our resource persons, Dr. Sunanda Bharti, Dr. Avekta Verma, Dr. Amrendra Ajit, Dr. Anju Sinha, Dr. Parveen, Dr. Gurpreet Singh, and Mr. Anil Sain. The resource persons have years of experience educating future legal professionals. I'm really thankful to you all for taking the time out of your busy schedule to interact with the students. Indeed, your experience of teaching these subject options and would provide an overview of syllabus and the expectations that a student should have while taking a subject option. The purpose of the webinar is to enable students to rationally and with proper application of mind decide the subject option that they would like to study in the upcoming fifth term. Post the webinar, kindly note, the subject option forms will be made available and on the Law Center 1 website. So the same poster on which you saw the notification is the one having the link to the subject option form. Please fill the subject option form, and the subject option form will be available from today evening 7 p.m. to 5 p.m. on Monday, that is of August 16th. With this, I extend again a very warm welcome to you all, and now I invite Dr. Amrendra Ajit to discuss Jurisprudence second.
Thank you, Shivika. Very good evening to all of you and our colleagues, students, all. I am going to talk about optional paper Jurisprudence 2. May I share my screen, Shivika?
Yes, sir. Please share your screen.
Yes. So, I'm going to discuss about Jurisprudence Part 2. You have already read about Jurisprudence 1 in your first semester. And it is I will say it is the left part of Jurisprudence. That means whatever not taught in the first semester, that has been kept as a Jurisprudence 2. Earlier it was within the Jurisprudence paper as a single paper when there was no legal method and legal history, because now it has been added in Jurisprudence 1. So some portion of Jurisprudence was now it is kept in Jurisprudence 2. So what is the importance of this paper? You have already read about Jurisprudence. So it is a fundamental paper of law, because any law gets its validity from the jurisprudential aspect only. This one paper was a compulsory paper and second has been kept as an optional one. Optional why it has been kept? Because in this part we used to read only certain concepts. Okay, and compulsory part now we have included legal history, legal methodology, as well as some part of schools. So in jurisprudence one, you have already read legal method, Indian legal history, basic theories of law, schools like analytical, historical, sociological, and their proponents. Now we offer in jurisprudence 2 only certain concepts. What are those concepts? So in this jurisprudence 2, there are only 6 modules. Within 6 modules, these are your 6 modules for jurisprudence 2. First is about the concept of rights and duties from the perspective of jurisprudential analysis. And second is about concept of rights and duties, philosophical analysis. That third is about liability, fourth is personality, fifth is about property, and sixth is about possession and ownership. So here we will study only about concept of rights and duties, liability, personality, property, and possession and ownership. Okay. Now in some detail. So topic 1 covers the jurisprudential analysis of rights and duties, which you have already read some part in jurisprudence 1, because the last part of the jurisprudence 1 is about rights and duties. But here you will read in detail, and so 2 module has been covered only on the rights and duties. So in the first module, you will read about the view of different scholars and different schools of rights and duties, various theories about rights and duties, what are the kinds of rights, what are the kinds of duties, then relationship between rights and duties, jural correlations. In this, we have read in jurisprudence 1 also, but here you will read in detail, because there you have read only 1 article, here you will have to read 5 articles in syllabus. Of Eldian model of jural correlates, jural opposites, jural contradictories. Okay, this is also called as right in wider sense. So you will read here right, no right, duties, power, immunity, liberty, liability, and disability. Topic 2 is about application and philosophical aspect. That means philosophical aspect of rights and duties, as well as modern application of these rights and duties in the present context. So generally we used to read under this different aspects of rights and its application in the present context, modern concept of rights and its Marxist view, then expanding domain of human rights, including cultural, community, freedom, privacy rights, because cultural and community rights are also becoming so much important during these IPR eras. Third topic is about liability. You might have read into first year and second year different kinds of liability, because liability start with the tort itself. So within tort itself, you have read various kinds of liability, just like vicarious liability, absolute liability, strict liability. Okay. So here you are going to study about the philosophical foundation of these liabilities, that why these liabilities has been created. To some extent, you know the reason, but not in so much detail. So here you will read about this detailed concept of liability, nature of liability, theory of different kinds of liabilities, civil, criminal, vicarious, absolute, strict, exceptional, and then after exceptions of these liabilities. Then about personality. So here we will read about the person, natural as well as legal, under this concept. And under this, we will read first of all who is person, what are the kinds of person, kinds of theories of natural nature of legal person as well as natural person, legal status and rights of animal, unborn generation, what we call these days intergenerational equality. We talks about sustainable development and all. So the basic concept lies in here, that how you are recognizing the future generation as a personality, and rights of dead person, legal status of dead person. Then evolution of modern corporate structure, how this came into existence. Okay, what are the rights and liabilities of this modern corporate, legal status and rights of corporation, and theories of corporate personalities. Fifth is about property. That means meaning and kinds of property, different kinds of property, movable property, immovable property, okay, tangible property, intangible property. So there are now nature of property has been changed. Now it is not only what you are seeing and what you can touch it, that is only property. Role of intangible property has been increased so much. So the nature of property, how it has been changed, you might have read in this intellectual property law also, that how the concept of property has been changed and how they have been recognized in this modern trade and corporate law these days. Theories of property by various scholars from the all perspective natural law schools also. That means what was the concept of property in earlier is, what is the concept of property in this is, how it has been justified, how new concept of property has been justified on the basis of old concept or certain modification in that. So all these things you will read in this part. And then after that is relationship between property and ownership. Okay, that means what are the characteristics of property. Within that we will see that what are the relationship between property and ownership. And the last part is possession and ownership, because it is called as the possession is important part of ownership. Okay, so sometimes possessor is more powerful than owners in certain cases. How it can be, how you will determine that ownership will go with someone, because there are so many interesting cases under this chapter also. Suppose take the example that you find note in the shopping mall or any shop. Who will be the owner of that particular note? Okay, how you will determine that, because there was the jurisdiction of the shop also, and you found it, no one has claimed it. So how you will determine? So there are various case laws under this, and those case laws are very interesting case laws, that how to determine rights of possessor and ownership. So ancient concept of possession you will learn here, and ownership concept, a modern concept of possession and ownership. What are the kinds of possession and kinds of ownership? Various theories. Within these those theory we used to discuss those case laws and relationship and differences between possession and ownership. So it is overall about this only concept part, that is the jurisprudential concept of these five concept: rights and duties, ownership, possession, liability, and all. Okay, so it is about completely a philosophical paper to understand the legal nature of this concept, because these concepts are very important in any paper, whether you are choosing any optional paper or any basic paper. Just like take the example of constitution, unless and until your concept is not very clear about rights and duties, okay, whole concept constitution is based on those rights and duties mainly. Then possession and ownership, liability, these days how to fix the liability, and liability to whom? Liability to natural person, liability to legal person. So I think this paper is a very fundamental paper, even though because due to the scarcity of the compulsory paper, this norms of DCI, we cannot keep as a compulsory paper. So in optional paper, it has been kept in that way. Okay, so it is a, I will say that it is a fundamental paper to understand all these concepts. So this is from my side for the jurisprudence 2. If any question you want to ask, you can ask, or if you want to later on, then that is not a problem. Yes, thank you. Thank you, Sivika.
Thank you, sir. Thank you for enlightening the students on jurisprudence, the second part. And with this, now I would like to call Mr. Anil Sain to discuss the paper of information technology law. But before I do that, I have a request to all the students that this is a webinar for those students who are going to enter the third year or the fifth term. So everybody who is from other years, please kindly withdraw from the meeting so that the students who will be impacted by the subject options can choose them. With this, sir, I request you to please take the center stage. Thank you.
Thank you, Shivika. I'd like to just share a tab so that we can start with it. And most probably with starting of this one thing comes to the mind that what is the paper? And if I opt for this paper, how and what will I learn? When I say how, certainly the question comes up that since there's a technology around us, and today, if I talk about it, earlier it may be that certainly there are essence of life, but you'll be glad to know that certainly in some countries, bandwidth or the internet has been recognized as a fundamental right. So when I talk about this information technology law, what do we have for you? Because you happen to be in the third year, and what are we offering you within the subject? When you'll be learning this particular subject, what all situations you can apply it up in your own ambit, how you can use the provisions of the law, your rights when you'll be aware about them. Rights, when I say, sometimes just sending a text, receiving a text may be an offense, but may not seems to be an offense until it's reported. Along with it, you may also protect yourself, safeguard your interests. When I talk about it, I'm just keeping in mind that yes, there is a freedom of speech and expression, and to the extent of that, when I talk about the privacy laws which are coming up. So with this, that life has become a more of a bandwidth. Let me start with this paper, that is information technology law. It has been divided into two parts. Part A is talking about Information Technology Act. When I say Information Technology Act, it talks about that why do we have IT Act? Why do we have it in the year 2000? Why not later or earlier? There are reasons to it. And if you talk about Information Technology Act, why was it perceived as an idea that it will be the one law which will deal with cyber law or cyber offenses? Many times cyber law, cyber offenses, why they have been coming up, all the reasoning will be provided within the part A only. And then when you talk about part B, it talks about how the other laws, when I talk about other laws, I'm keeping in mind that there is intellectual property rights, when it keeps over there and touches upon, and there are certain contracts by which under the Indian Contract Act, we have to intend to determine the jurisdiction. So with this part B, both of them, part A and part B, have been divided into units. And if I talk about these units, what all are they covering up? First, part A will be talking about that there is an Information Technology Act. Yes, everybody knows because it's been rightly from year 2000. But right now in 2021, what is the relevance? Why should we know it? We should know it because we have to find the idea behind such law, which was framed in India, and nowadays being dealing with the situations where we actually look into cyber crimes, which have been divided into two parts. So the introduction will be talking about the genesis. Why do we have this IT Act? Could there have been any other reason? If IT Act was the one mandate during 2000, can we by any guess or stretch of imagination say that it was the technology that was booming up in the year 2000? If year 2000 was a technology boom, then why can't our correlate 1980s when it was a telephone era that every household was actually looking for, that there should be a telephone at their doorstep? Or why can't I say that 1986 should be the era when it was the Dell computers? They have started that over a telephone, they were actually involved in the activities of e-commerce and selling the desktop. And if I have to sideline into that one, how can I coin these ones under the objective that we have today, IT Act? So when we talk about IT Act in the introduction part, you'll be covering up that certainly along with these reasons, there was United Nations which have actually talked about the model law. And that model law was the idea behind having IT Act. So basically the foundation was laid down in the year 1996, and certainly in the year 2000, we were under a mandate to introduce this particular law. Thereafter, under the introduction, you'll be also covering up with the definitions. When we talk about the definitions, we'll talk about, first of all, we're talking about a technology. How can I define technology? What should be the first definition that should come to my mind? So if I talk about internet, internet, when we talk about, can be actually technologically divided into 3 or 4 kinds of network: LAN, MAN, WAN, along with Wi-Fi, Bluetooth, and others as well. But when we talk about that, what should be the law aiming at? So the first definition that we thought of was computer. But nevertheless, this computer definition provided was limited. So we need required to actually come up with another definition which shall deal with computer systems. This definition was also limited. We needed computer networks. So now if you look into it, defining computer, computer system, computer network, and all these definitions constitute as a computer. So moreover, that practicality, a challenge was before us when we introduced this one, only to implement what United Nations by way of model law on e-commerce has come up in the year 1996, so that we can see it. Now, what was United Nations talking about will be all part and parcel of topic unit 1 that will talk about introduction. When we talk about unit 2, unit 2 will talk about and aim at one of the most important and crucial ambit, which is an extension of United Nations model law on e-commerce, because actual aim of having this IT Act was give a recognition to alternate to paper-based commerce. What is alternate to paper-based commerce was actually defined later as e-commerce. What is e-commerce? E-commerce required there should be a legal sanctity that under Indian Contract Act 1872 we have seen that we tend to do. That is, to do or abstain from doing should be implied or expressed. And when we talked about express, and that too in the technological mean, gave us a challenge that how to recognize that whether this has been sent by the same person who intended to conclude a contract. So for that reason, electronic records was recognized, and to give a sanctity and authenticity to this electronic record, there was a model law on electronic signatures that was in the year 2000. What was the signature? Signature talked about two terms. One was digital signature, other was electronic signature. So when we look into these parallels that we find, the law was recognizing that it is time to introduce legal documentation, legal recognition to electronic record. Electronic signatures came in. Electronic signatures, to give a sanctity, had undergone a change in the year 2009 and 11 in India. When we look into it, there was a change which was introduced in the legal recognition so that that could be implemented. Now, what was the purpose of introducing a signature? Because email sent over the internet, received by the person, and over a telephone conversation that could have been communicated. But nevertheless, it required that who has sent it. Basically, I wanted to know who is the person behind it. So the idea of authentication was there, and to actually conclude that one, digital signatures as a legal field was introduced. And digital signatures are totally different from electronic signatures. So what was digital signature doing up? The authentication technique behind it, and why did we introduce electronic signature as a concept to conclude that one. So all these parts will be covered within this part A, unit 1 and 2. Unit 3 and 4 deal with the liabilities that we have recognized. You'll be glad to know that certainly when we were adopting this UN General Assembly resolution to implement the IT Act, we had actually seen and asked for, invited for suggestions from the police that what are the offenses that are being coming up, how they are to be concluded, and if at all the same offense under IPC is committed through Information Technology Act or through use of computer, how they can be looked into. For that reason, we have actually come up and divided into civil liabilities and criminal liabilities. When we talk about civil liabilities, we wanted to know what kind of dispute is arising. Why the dispute is arising? Because till the year 2005, if you report a crime of data theft, certainly the police personnel may not be aware about that you are actually talking about a data theft under IT provision, or you're talking about a theft under IPC provision. So that sort of a dispute, if it actually coming up, how they are dealing with, then there was a damage to a computer system. It may be looking as a physical damage, but it was quite difficult to prove that there has been a damage to the data, which happens to be essential part of the entire creating or maintaining the data record. For that one, data protection had come up. When we talk about data protection, yes, privacy issue had come up. Then company and corporate houses data became important one. And ultimately for that reason, today, when we call about that, the life has become more like a bandwidth. And today, when we see the appliances around us, all of them or most of them connect to the internet. So that data protection, if the data has been taken by somebody else, misused against you, there is again a remedy under the provisions of IT Act. Then there was a most important one, that is online defamation that we talk about. What is this online defamation that we look into it? Why and how online defamation can be concluded? If I'm sending a very unique message to one particular IP address, fine, certainly there was a conversation prolonged, but does it amount to an online defamation? So the criteria were required into it, and for that reason, we actually looked into that, yes, there will be IPC read along with IT Act to meet up the requirement. Same way, when we look into the criminal liabilities, it became very difficult that what does amount to tampering. What is tampering actually? You must have heard about the terms hacking, the second term ethical hacking. Both of them actually, one with the consent and where there is a person who is taking up the security system and he asked for these services, it is ethical hacking. The other one is trying to gain access to your computer system, computer machine, only to take undue advantage of the data which is being kept over there, or the applications which have been installed, or maybe the programs, or using your mail or somewhere a communication passage that has been made up in your system. Then there is a theft correlated as data theft. Today, if I ask you one thing that, yes, day before yesterday, I lost my pen drive. I'll say, okay, fine, not to worry, because it hardly costed 600 or 700 rupees. It is an easy thing to say it. But what about the data that we are talking about? What is the data has to do with it? How can I protect that data? Because that data, maybe in the pen drive, which is costing 700 rupees, is the essential one. So if that has been used, misused, what are the remedies under the IT Act? That is to be seen into it. Then most importantly, obscenity and pornography. Under section 292 of IPC, when we talk about it, obscenity, from the down the line from 1980s, reaching till 2021, how the technology has changed the behavior of seeing that these offenses committed by means of computers, computer appliances, or maybe mobile phones, or any other device which is qualified as a computer, what are the degree, how to recognize that one? Because if I look into even the definition of section 292, it has over a period of time given a different interpretation with respect to different cases, and that has been looked into. Now, cyber stalking, cyber terrorism, and if I look into criminal liabilities, it is just 1 year. And if we look into the rise in crime, let me say in India only, there has been 33% in only 2 months that was reported last year, May and June. Only in 2 months, there was increase in Bombay, and that has been reported that there has been crimes related to obscenity and pornography. Rise is more than 33%. So that is one thing that we must look into, that it is the one which is coming up. Ultimately, the Unit 5 deals with the cyber security. When you talk about cyber security, yes, the national security provisions, these provisions have been implemented by way of rules and allied provisions which have been inserted in the IT Act. Why was it required? It was required because the situations which were terrorist attacks or people landing upon Indian soil and giving or shaping up a crime actually was the one which was our concern. And moreover, when we talk about interception, blocking rules, they were the ones which were actually in 2011 given a shape that how it is to be done, how long will it take to block something or intercept something, whose permission is required. All these rules by way of a law was incorporated so that there is no second Bombay attack that could take place. And that has been actually in Law Commission report that has been clearly highlighted the objective of introducing these interception and blocking rules, that yes, there should not be second such attack that should take place, which has actually shaken up the Bombay as a city. So in that phase, when we look into it, these cyber security measures were introduced. If we recollect, the last year also, with respect to the Zoom, there were cyber security measures which were introduced. So government from time to time, mighty, that is ministry, actually from time and again, introduces the safeguard, what is to be done, how it is to be done, and how you can safeguard your data privacy. Last one is an interface which is being covered up in the light of freedom of speech and expression, along with the right to be forgotten over the internet, because there is a right now ongoing litigation and started from US, that is Bill of Rights, that how they actually were looking into that I have a right to be forgotten as well. But in India, when we looked into it, that how this could be excised within the reasonable ambit, that is 19(1)(a), how we can excise that one, because 19(1)(a) to be read with 19(2), freedom of speech and expression, in the light of how we can give it a shape, that there is a right to be forgotten. And if at all that is required, how these privacy laws will be incorporated. Now, there is another part B in the same extent. That part B talks about allied, basically information technology getting affected with the other subjects in this one. So the chapter 6 talks about electronic contract. Over here, we're going to be talking about Indian Contract Act 1872, its relevance in the light of formation of a contract on electronic medium. That is where alternate to paper-based commerce and how we were giving a shape. So this one, we actually come across web click contracts, email contracts, standard form of contracts, and there is a United Nations Convention on use of electronic communication in the international contract. Why is it important? It is important because we may not know that by the end of the day, when you start using the technology, may it be mobile phone connected to the internet or anything connected to the internet, even to gain access where the internet is in essence part of the entire system, you actually conclude signing more than 50 contracts, and that has been reported that this is the minimal contract that is signed by the individual. Why? It could be web click contract, it could be email contract, and that could be standard form of contract also, where you click on I agree to the terms of condition or terms of service. So we're going to be drawing a line and distinction by this particular one. Then seventh one talks about trademarks and domain names. When you look into trademarks, what trademark? Essence of Trademarks Act. Why domain name was being recognized? Because domain name was introduced to only serve a purpose that it was difficult to remember IP addresses, where IP addresses allowed you from one particular address to actually develop a communication with the other address. It was difficult to remember 255.255.255.255.255. These four combinations. So what happened in 1990s? It was Tim Berners-Lee who had introduced www, World Wide Web, and that is how this domain names had come into play. Now, domain names being correlated as a goodwill as to the business, and how these domain names had come up. So this is also recognized as cyber squatting. When we look into these, with respect to these domain names, there has been dispute which has been arising, that who is the first owner of this particular domain, who should be allowed to use this particular domain. For example, Maruti.com should actually, I'm just thinking right now, should belong to Maruti Suzuki, but it does not belong to Maruti Suzuki. So in this manner, when we look into it, who has the first right, and in case there is a domain name dispute relating to infringement and passing off, how the law of trademark will be applied along with IT provision to settle the dispute, and what is the recourse line. So these are the other ones, and the last one we're going to be talking about jurisdiction in the cyberspace. That what is the jurisdiction, how we have to recognize the jurisdiction, because internet does not have a boundary that a nation can actually draw in clarity. When we look into it, for that reason, what are the rules of private international law that are applicable? What is the jurisdiction on internet? How we see it, how we extend, and what are the perspective of this one? If at all, somewhere when we see in the light of provisions of IT Act, can there be extraterritorial jurisdiction under IT Act? If at all, how? And for that one, there have been leading international cases that we pass a reference, also in Indian courts that are recognizing the jurisdiction for internet will be based on different parameters that we have adopted by way of doctrines, and they have been instrumental in good interpretation that, okay, fine, that where does the right or remedy lie. So this is all which will be covering, which will be covered in the subject. And if you have clarities, questions, queries, please feel free to ask right now. Thank you, Anshul. If you have queries or anything, you are free to ask right now that you actually think that it requires from my end.
Yes, sir. One question, sir, I would like to ask.
Please,
Sir,
Ramesh.
as this is a IT Act, I want to know that ITs keep on changing. Like currently we are having AI, data science, IoT, and all sort of things. So
Yes.
is this IT Act will regulate these changing domain also? Or
Yes,
we
so
need some
when you talk about, Ramesh, as far as I understood, you're talking about artificial intelligence, that how far IT Act will be applicable to these AIs, right?
Yes, sir.
So for that one, let me tell you over here, IT Act is competent to actually deal with anything which could be defined as a computer. For that reason, we must be very clear that how and what should be a computer. Now, to take an example, if you remember, there is a technology of CDMA, right? Code Division Multiple Access, which was introduced by Reliance and thereafter followed by Tata, right, Ramesh?
Yes, sir.
Now,
CDMA and TDMA.
yes, I'm just talking about CDMA right now. If you look into the handset which they offered was just Nokia, which had a keypad and which was capable of sending and receiving the text message, right? In that light, but it also allowed you the access to the internet. Over there, the court have held that if there are minimum requirements which are provided under the definition, that is input, output, memory functions, And capacity of data storage, irrespective of what is the data storage, it qualifies as a computer. So wherever AI will be looking into it, certainly this act has an answer and a response to it. Also, we are looking forward for PDP amendments, and moreover, if the time permits, the respective teachers will be taking up that as well. That why do we are looking to privacy or data protection bill? Why? What is the necessity on that? I hope I answered your query, Ramesh.
Yes, sir. Got that.
Yeah.
Answer.
Thank you, sir, for
Thank you, Shivika. Thank you for inviting over here.
thank you for enlightening the students on information technology law. With this, I would now request Dr. Sunanda Bharti, Associate Professor at Law Center 1, to please enlighten the students on intellectual property rights law, the second part.
Thank you, Shivika. I hope I'm audible.
Yes, ma'am.
Right. Okay, so I do not have any PowerPoint presentation, but still I'll try my best to put across the nuances of IP2. Now, intellectual property 2, IP2, is all about higher order IP laws. And uh, we have the most comprehensive and updated coverage of various IP laws in our course material. So let me begin by underscoring at the outset that in terms of content, IP2 stands second to none. And when I say second to none across the globe, actually. It is both IP1 as well as IP2, the course content is updated regularly, whether it is in terms of the substantive changes in the black letter law, or whether it is in the context of case laws. We update it regularly, and it is a very comprehensive reading material, both IP1 and IP2. So presently the focus is on IP2, which is an optional subject. But as you know, because I have to continuously relate it to what we have already studied as a compulsory course in IP1. So as the students would know that in IP1 we had the law of trademarks, we had design law, we had GIGA, that is Geographical Indications of Goods Act. Here also, so we read basically three legislations. Here also, in IP2 also, the emphasis primarily is on three statutes. So we'll start with the Copyright Act 1957, and then we'll proceed. Copyright law basically forms the major chunk of the semester, right? So it is that legislation with which we deal very comprehensively in great detail, right? And then it is followed by the Patents Act 1970, which also in that also the coverage is sufficiently decent. And then we have the PPV FRA, which is comparatively a new legislation in the sense that, or at least insofar as the relevancy of it is concerned, it has become relevant of late only. PPV FRA is Protection to Plant Varieties and Farmers' Rights Act, 2001. And then there is a bit about TK, that is traditional knowledge and folklore, that is traditional cultural expressions, which has by and large been recognized as intellectual property, but we do not have a legislation as such on the same, right? So these are the four components with which IP2 would be dealing with: the Copyright Act 1957, then the Patents Act, then the PPVFRA, that is the Protection to Plant Varieties and Farmers' Rights Act, and then the last and the fourth module or the unit is TK and TCE. So let me just take each one one by one, as in brief. Yes. Yes. Do we have a question? I heard something. Somebody unmute. Okay. So under copyright law, that is the first thing with which we usually start. you as in the students will have the opportunity to work, to basically learn about a variety of diverse topics, from whether say, for instance, the famous case of the due photostat case, from whether the Delhi University has a right to incorporate or use copyrighted articles in the reading materials for the purpose of education, to whether a certain TV star has the right to that is copyright to the tattoo that he or she might have made on on his or her body, to whether say Justin Bieber or Kim Kardashian have the right to use on their social media handles the pictures of themselves clicked by the paparazzis. So all these are topics that are contemporary, and this is just to give you an idea of how diverse and contemporary, basically, and relevant the course is, at least the copyright module is. So the topics are very rich and exciting. In fact, when it comes to the copyright law unit, copyright law may sound dry to begin with, but it can actually be very interesting. So it all depends on how enthusiastically you take up the subject, right? So the first thing is copyright. The first unit is copyright law, and then we have the patent law module, or the patent law unit, and it begins with the fundamental, you can say, justifications for creation of patent rights. Why exactly we have patent rights? What does it protect? What can be patented? What are patentable inventions and what are non-patentable inventions? How a patent is different from copyright or a trademark or a design. And this differentiation is so very basic and fundamental. But yet students or law students, that is not IP students as such, but in general law students, they tend to goof up on what exactly is the domain of each and every intellectual property law, right? So what is protected by patent? These terms are related, no doubt, but they protect different domains of intellectual property, right? So all this you're likely to gain a very clear insight as to what exactly is protected by what law, right? And what is patentable, and then we deal with the aspect of compulsory licensing. Yes, compulsory licensing, technology sharing, again some very very relevant and contemporary subjects. Evergreening, the controversial, some controversial topics such as evergreening, generic drugs, and so on. So topics that have acquired the status of hot news in the current prevalent COVID times, right? When it comes to drugs particularly. So all these would be discussed, and then of course there is the substantive or the procedural aspect of the process of registration of a patent, the the requirements as to what requirements need to be fulfilled by a person in order to get a patent on a certain invention, what are the conditions for on the basis of which the patent office would be refusing the grant of patent to you, and so on and so forth. So we'll be looking into the process of registration and the grant or refusal of patent, and then finally we'll be exploring the strategies for dealing with patent infringement. So if your patent is infringed, that is, there has been a violation of this statutory right of yours, you exclusively had the right to use that or exploit that patented invention, but somebody else has been doing it without your authorization, then what is your remedy available to you, or whether it is infringement in the first place. So all this is module 2, that is patent law. And then we have module 3, which again is very, very relevant, or rather it has acquired a very acquired a new sort of an importance of late, as in recently. And the third module would be the PPVFRA, that is the Plant Varieties Act, Protection to Plant Varieties and Farmers' Rights Act. So as the name itself suggests, or is self-explanatory, so to say, farmers' rights, which were so much in news in the current times. But so PPVFRA is a sui generis sort of one of its kind legislation to provide for the establishment of an effective system for protection of plant varieties. And as I said, in the current situation, farmers' rights have gained prominence, though PPVFRA would be focusing on just the intellectual property aspect of the farmers' rights, of what rights, IP rights, the farmers have in their produce or in their breeding techniques or growing techniques. Right, so it tells about the rights of farmers and plant breeders on their produce, but from the IP perspective. And so basically the aim is to recognize and protect the rights of farmers in respect of their contributions that they tend to make that they have been making since times immemorial in conserving, in improving, and making available the plant genetic resources for the development of plant varieties. That's the whole, you can say, if I put it simply, the crux of PPVFRA. So that is the third module. And then we have the last and the fourth module, which is the smallest. And smallest because, as I said in the beginning itself, fourth one is TK or TCE, traditional knowledge or traditional cultural expressions. We do not have any legislation on it, and it is an emerging field of IPR, and which has gained, which is very, it is specific to a traditional country like India, or it is very uniquely important when it comes to a country like India, because we in India have a number of traditions that prevail, and a need was felt that, okay, all those traditions, traditional practices like traditional water conservation methods, traditional farming methods, traditional fish culture methods, traditional art of paper making, so on and so forth, all these practices also, they are unique to this country, and they need to be accorded some protection. Or all those communities or individuals who have been since ages and since generations have been responsible for maintaining this tradition or the aesthetics of the tradition, they should be benefited somehow. So that was the idea why we talk of traditional knowledge or traditional cultural expressions as a part of intellectual property, and that is the fourth module. So these are the four modules which comprise IP2. Now, in general, let me, if I'm allowed to put it this way, one USP or the unique selling point of IP2 or IP as such is that if you take up this course, you are really interested in the field, the internship and job potential becomes very strong, very, very strong. And so it enhances your professional prospects. So in the sense that it could help you give an edge in the hiring environment, in the current hiring environment, where many legal employers may want to recruit, and they do want to recruit specialists instead of generalists. Okay, so rest of course depends on you, the individual student. You can develop develop knowledge or interest in your own practice areas, ranging from, say, I'm interested only in trademark law, or I'm interested in only copyright law, and so on and so forth. So this is all about IP2. One last bit that I would like to end with is that while IP lawyers may not be showcased often, they are usually very low-key people, but very well placed and earn well also. So while IP lawyers may not be very may not be, you know, showcased often in the television serials and the movies, because that domain is exclusively reserved for criminal lawyers, and they are also very weirdly portrayed. But nonetheless, but the work that the IP lawyers do is nonetheless very important and equally relevant, if not more. So it's a very, very relevant subject. It's an optional paper, so kindly choose it only if you have a real, you can say, interest in pursuing it as a profession, right? Or you want to pursue it in the sense of making a living out of it. Yeah, thank you so much. Over to Shivika.
Thank you, ma'am, for talking about the relevance of IPR, the second part. Ma'am, we have one question from a student, Ramesh Chandra Singh, who's wanting to know that if one does this course, that is IPR 2, would it be complete in the domain of IPR law? Like, would this complete his understanding of IPR law?
Okay, good question, Ramesh. See, since it is IP2, that means IP1 is there is something known as IP1 also, which is in the fourth semester, second year, and IP1 also has a number of statutes. That course also has a number of legislations that we deal with in detail. Trademark law is there. There is a design law, and there is geographical indications of goods act, and they are very important IP fields. Fine. So only by doing IP2, your knowledge of intellectual property would not be complete. And I'm afraid, no. The answer is no. But if you were a student, I think IP1 is a compulsory subject, and then you are taking up IP2. Yes, after doing IP2, by and large, your knowledge of intellectual property would be complete. Though not, yes, though not complete in the complete sense के सारा सब कुछ मुझे पता चल गया है IP का. No, definitely not. There is so much more to it. Which we do, like we have integrated circuits, the non-integrated circuits, which we do not focus on at all in either in IP1 or IP2. We have portions of bits and pieces of within these legislations which we do not cover as such because of various reasons, and primarily paucity of time. We can cover only this much within a semester, and it is with that thought that these courses are formulated. So, but by and large, yes, 80% of it you would be knowing if you have completed IP1 and IP2.
So, ma'am, basically, after completing this IP2, I don't have to do other courses outside. I mean to that after passing 3 years of LLB. That's my question, basically. Does I have to do LLM or something specialized course from any institutes which are expert in here?
See, other courses, now other courses is a very vague term. Other courses in the sense of a specialized LLM, that would expose you to the international aspects of these fields. Definitely. So that aspect would definitely be an addition. Because here we do deal with the international portion, but we do it sketchily. The focus is more on the national legislation, the laws of India, right? The international conventions, treaties, all those points, we just gloss over it, right? As I said, that international part of it would be your knowledge of international law in relation to intellectual property. That would definitely be an addition if you choose to do an LLM specifically in IP laws. But insofar as other certificate courses and diploma courses and 110 other different courses that are available is concerned, this particular course is far more superior to all that.
Okay, ma'am, got it. Got that point.
Yeah.
Thank you so much, Sunanda ma'am. With this, now I request Dr. Parveen to please talk about business regulations as an option subject in the fifth term.
Thank you, Shivika. I don't have the PPT presentation. Business regulation paper for fifth term is an important subject. Of course, it is optional. If someone want to go in commercial law practice, then it is very useful, because most of the, as the name suggests, business regulation, that means how business is regulated in India, will be covered. Not everything, but by and large, it will cover the major areas dealing with business. This course starts with the general understanding of the business and trade, and what is the difference between these two terms, trade and business. We start with the constitutional foundation regarding right to trade and business under Indian Constitution. It is one of the fundamental right of a citizen, of even non-citizen, to carry on their trade and business in India. But it is not absolute. In some areas, you have state monopoly. When India got independence, and in the initial stage, it was all state controlled, and it was control which was exercised by state, how much commodity is to be produced, at what rate it is to be sold off, at where can you sell. All these things were controlled by state, and whether can you expand your operations or not, can you expand your plant, they were all under state right at that time. But with the passage of time, particularly in the late 80s and early 90s, when we liberalized our economy, we allowed private investment to come, we shifted from control to regulation. That means state will not uh, uh, carry on so much trade, rather it will allow private to carry on trade. And that is why you have more or less private players in all sectors, except one or two. You have private players which requires to be, so to control them you need state, so that they cannot abuse their position to the detriment of the public interest. So in our constitution we have reasonable restrictions, because no fundamental right is absolute. So likewise, freedom to carry on trade and business is also not absolute freedom. There are reasonable restrictions which state can impose. Other than that, state can monopolize also some trade if state thinks. For example, these liquor licenses are distributed or allocated or issued by the state government. So state has very important role to play here. Then we cover the specific sectors in business regulation. For example, the SEBI, that is Security and Exchange Board of India, is very important regulator. In fact, it was the first regulator. We talk about that, okay, you bring reforms in all the factor of productions, this being security market or financial market. So that reform was brought by bringing SEBI. Earlier SEBI was in existence, was brought into existence only through ordinance, but later on act was passed. Recently you might have seen this series also, scam based on Harshad Mehta, that how he duped people, or how he took advantage of the rules. and how this Sucheta Dalal exposed that scam. So in this business regulation, we will thoroughly deal with SEBI, what are its functions, how it works, because most of the regulators now they play all the roles. For example, they lay down the rules of the game, they enforce these rules, they also impose punishment also. So you have separation of powers doctrine, but here you will see that all these three powers, that is power to make legislation, power to execute them, and power to adjudicate, is vested in a statutory body. So we discuss SEBI prohibition of insider trading regulations and how it is controlled, what role SEBI has, how these Ponzi schemes are controlled by SEBI, and then how stock exchanges are regulated. After this, we discuss with Sarfazi Act. Sarfazi Act or Securitization Act again is very important act, and it was brought to control this menace NPA, that is non-performing assets. So here we see the procedure, how security interests are enforced and what role the court has, because now court's role have been minimized by way of this Securitization Act, and most that is why wherever securitization disputes are there, they are settled quickly. So the time has reduced substantially. Then we discuss about takeover court, SEBI substantial acquisition of shares and takeovers regulation 2011. Now you can say that this is more related to company laws. Yes, there is some overlapping also with regard to this SEBI substantial acquisition of shares and takeover regulations 2011, which was amended in 2017. So we examine various rules regulating takeover in India. Then we discuss about money laundering. Money laundering again has become a source of black money, how black money is generated and how it is controlled. That is why in 2002 Indian Parliament enacted this legislation called Prevention of Money Laundering Act. So here we see that how attachments are done, how long this attachment of property can go on, and under what circumstances the property can be sold off also here under Prevention of Money Laundering Act. Then we discuss Essential Commodities Act 1955. In 2020, you might have seen this Essential Commodities Amendment Ordinance. Of course, now this ordinance has become law. So how this amendment has impacted essential commodities in India, because there was a lot of protest by farmers that these amendments should be taken away. So what commodities we call as essential commodities, and how there is control of production, supply and distribution of essential commodities. In 1955, state had huge responsibility, and that is why rationing was done at that time. There is not so much rationing nowadays, because there is lot of scope for market powers to determine the rates and supply of these essential commodities. But nevertheless, state has substantial control under the earlier law, but now it has reduced its control over regulation of essential commodities. Then we discuss TRAI, Telecom Regulatory Authority of India, Act 1997, And you have seen that as a result of revolution in communication technologies, TRI's role, in fact, TRI has successfully implemented many things in telecom sector. Due to TRI's efforts, the rates of call rates have dropped substantially, and you have 4G, 5G. How it regulates telecom sector will be discussed in this unit of business regulation. Then some new things have been added. For example, this new legislation called Real Estate Regulation and Development, called RERA Act 2016. So how real estate projects are registered, uh, what are the powers of RERA, which is the authority in real estate sector, then what powers they enjoy, what penalties they can impose, how adjudication is done. So all will be discussed under this head. And last regulator which is included is IRDA, that is Insurance Regulatory and Development Authority, which was established way back in 1999, and it has substantially changed the face of insurance also. Earlier, life insurance was given only by the this business in life insurance was the prerogative or monopoly of LIC only. But with the opening of this sector, now private players are there to offer life insurance schemes. And under this, we will discuss the role and powers of this body called Insurance Regulatory and Development Authority. So with this, I finish this course, that is business regulation. But this course is mostly important for if someone want to go in commercial litigation. It will help a lot because there are law firms, and other than that, there are the sector regulators which offers internship to students, and sometimes after passing your LLB exam, they also offer positions for fellowships, or there are think tanks where research are conducted on these particular regulators' powers. If you have any question, any query, you can ask. You are most welcome. I think no question. Yeah, sweet.
Thank you, sir, for talking about the future implications of taking up business regulations. I'm certain the students would have benefited from that. I now request Dr. Anju Sinha to please provide an overview of rent control and slum clearance.
Thank you, Shivika. A very good evening to all of you. I'm here to give you an overview regarding the subject Delhi rent control and slum clearance. But before giving overview regarding the subject, I would like to tell you regarding the relevance of this particular subject. Now, this subject is very important if you are intending to appear in competitive exams, particularly Delhi Judicial Services or other judicial services. Because in judicial services, generally, a question is asked from a particular area, like eviction, the grounds of eviction of the tenant. Generally, you get a question from this particular area in competitive exams. Or if you are intending to join the field of litigation, then also this is very important subject for you, because a major chunk of civil litigation is based upon landlord and tenant disputes and their relationship. The title are the disputes regarding title. So this subject is going to help you both ways, whether you are intending to join the profession or you are intending to appear in competitive exams. In addition to that, this subject will also help you in your day-to-day life, because many of you have taken premises on rent, or many of you may have given your premises on rent. So you are in a capacity of landlord or in a capacity of tenant. So in that capacity, you should know that what are the rights which have been given to the landlords and what are the rights which have been given to the tenants under Delhi Rent Control Act, and how the tenant is protected under the provisions of Delhi Rent Control Act, because Delhi Rent Control Act is more tilted in favor of tenant. So this subject, overall this subject is very important from examination point of view, like eviction, that problem-based questions which you get, I'll deal with that in later discussion. But yes, from competition point of view, from litigation point of view, and also from your day-to-day life point of view. Before giving an overview of the subject, I would like to tell you something about this particular subject, that why at all there was a need to have rent control laws. Because obviously we were having a general law. Transfer of Property Act was there. So why there was a need to have this additional law when a general law was there? The reason was that there was acute shortage of housing accommodation, and due to that acute shortage of housing accommodation, the tenants, they were exploiting their position. So what they were doing, they were just throwing away the tenants who were paying nominal rent or less rent, and again they were letting out their premises on higher rent. So this was a very prevalent practice, particularly during the time of after Second World War, because at that particular point of time there was acute shortage of housing accommodation. So just to overcome that difficulty and for the purpose of protecting the tenant from this practice which was being followed by the landlords, rent control laws, they were enacted in different states. We don't have any uniform rent control law. We have different rent control laws which have been enacted at the state levels. So we have Delhi Rent Control Act, we have UP Rent Control Act, MP Rent Control Act, Bombay Rent Control Act, so various rent control act we have. But more or less the provisions are similar to each other, and the object behind all these rent control laws are to protect the interest of the tenant. So this Delhi Rent Control Act, it was also enacted primarily with two objectives. The main purpose behind Delhi Rent Control enactment was, number one, to protect the tenant from eviction, and number two, to protect the tenant from payment of higher rent. So with this intention, this act was enacted. So obviously the provisions of this act, it is more tilted in favor of the tenant rather in favor of landlord. Because tenant was considered as weaker section of the society, and considering the tenant as weaker section of the society, special protection has been given to the tenant. So all these things we will be discussing under this particular paper. This paper, the syllabus is not very lengthy. Your entire syllabus is divided into 4 modules. In first part or module 1, you are going to study the basic terms which already you have discussed, which already you know, because you have discussed them under Transfer of Property Act. The general terms like lease, what is license, what is tenancy by holding over, why there is a need to serve a notice, and under what are the circumstances in which notice can be served by the landlord for the purpose of terminating tenancy. So this first topic, this entire first part, we have all general topics, but these general topics we will discuss in altogether a different context, because Transfer of Property Act, you know, you have studied in your last semester, in your first year rather. So those terms we are not going to discuss in detail. What we are going to discuss here in this particular part, that is why these terms are relevant for our purpose under Delhi Rent Control Act. Lease and license, the definition of lease and license you know, but why this difference is relevant under Delhi Rent Control Act? Why under Delhi Rent Control Act we are discussing the difference between lease and license, you know? So this is the main thing which you need to understand under this particular subject, because if an agreement between the landlord and tenant is lease, then the tenant will get the protection of Delhi Rent Control Act. But if it is license, the tenant will not get any protection of Delhi Rent Control Act. So that is why this difference is relevant for our purpose. Similarly, tenancy by holding over notice, again, what is the relevance of these terms in view of Delhi Rent Control Act? And under this particular subject, we will study 3 or 4 legislations. Like we will discuss Delhi Rent Control Act, Transfer of Property Act, Slum Clearance Act, and this Indian Easement Act. These are the 4 legislations which will be discussed in detail, and particularly in first part, all these except Slum Clearance Act, all the 3 laws will be discussed here in your part 1 in first topic itself. Then second part or second module, it deals with definitions, various definitions under the Act, various terms which have been used here, like landlord, who is a landlord, tenant, who is a tenant, because normally when we use this term landlord, we feel or we believe that landlord is a person who is owner of a particular property. But that is not true with respect to Delhi Rent Control Act. Under Delhi Rent Control Act, a person who is authorized to collect the rent will also be treated as landlord. So various definitions, who all persons will be treated as landlord under Delhi Rent Control Act, who will be treated as tenant, and also if the tenant dies, then what is the status of his legal heirs, whether the legal heirs of the tenant, whether they are entitled to inherit the interest in the property, or they are not entitled to inherit any right. So all these things we are going to discuss here under part 2. And at the same time, also we will discuss a difference between contractual tenancy and statutory tenancy. Contractual tenancy, where the contract is being entered between the landlord and the tenant under the general law. Statutory tenancy, where the tenant is protected under the provisions of the statute, like under the provisions of Delhi Rent Control Act, where in spite of his contractual tenancy being terminated, he will continue as a tenant and he will continue to enjoy all the rights which he was enjoying, which he was getting earlier in the capacity of contractual tenant. So the difference between the 2 terms we will discuss in detail with the help of cases which have been given in your case material. Then in the very same part, a very important topic is there, and that is regarding fixation of rent. Under Delhi Rent Control Act, the power is being given to the rent controller to fix the rent. And this power is being exercised by the controller on the basis of various circumstances, amenities which are attached to that premises, and after taking help of a valuer. But the problem with Delhi Rent Control Act is that once the rent has been fixed by the rent controller, after that, there is no scope of increase of that particular rent. The nominal increase concept is there. Section 6A of Delhi Rent Control Act provides that after a period of 3 years, 10% rent can be increased. Now you can understand this very well, that 10% increase means nothing. It's a kind of eyewash which has been provided here in the Act, because if today tenant is paying 100 rupees per month, after a period of 3 years, he will pay 110 rupees. So what increase the landlord is getting? It is only 10 rupees per month, which is not at all equal to the market price or other things which are related to the market value and other amenities which are attached to that particular property. So that is why the provisions of Delhi Rent Control Act, some of the provisions, because legislature is not coming forward to change the provisions. Look, all of you have studied constitutional law. You know that if a law is arbitrary, it is hit by Article 14 of the Constitution. And a law there may be a situation where a law is very much reasonable at the time when it was enacted. But later on, because the law has not changed in the changed circumstances, it has become arbitrary. So this is what exactly happened with these rent control laws, and particularly Delhi Rent Control Act. It was very reasonable law with a very reasonable object when it was enacted. But because it has not changed in the changed circumstances, and now after more than 50 or 60 years, keeping the rent freeze to 50-60 years back is not justified. It's arbitrary, and because the law has not been changed, so court has come forward, the judiciary has come forward, and some of the provisions of Delhi Rent Control Act, they have been stood down by the court, saying that it's unconstitutional. They are violating the fundamental rights which have been given to the people of this country. So all these things we will discuss under this particular part with the help of cases which have been given in your case material. Then next part, part 3. Part 3 is very, very important part of your syllabus from examination point of view, from competitions point of view, and from litigation point of view. Because most of the problems, they are related to eviction grounds. This particular part deals with the eviction grounds. Delhi Rent Control Act says that unless or until the landlord is able to bring his case under Section 14 of Rent Control Act, he is not even entitled to file eviction petition. So various grounds are given under Section 14, like non-payment of rent is there, subletting is there, misuse of premises by tenant is there, bona fide requirement is there. So various grounds are there, but again, the onus is on the landlord. It is for the landlord to bring his case under a particular ground and also to prove that particular ground. If he is saying that non-payment of rent is there, if he is saying the tenant has not paid rent for a past 3 or 4 months or 6 months, the burden is on him to prove that the tenant is in default of rent. If he is saying that premises has been subletting, the subletting is being created without his consent, the burden is on him to prove. So that is why I initially told you that the provisions of Delhi Rent Control Act, they are more in favor of tenant. They are more tilted in favor of tenant. Bona fide requirement. Now, bona fide requirement, initially it was a ground which was restricted to the landlord of residential premises only. But then again, when the legislature has not changed this particular ground, because it's arbitrary to restrict this ground only to the landlord of residential premises, then judiciary came forward, and in Satyavati Sharma, it was held very clearly by the court that this ground is open to the landlord of residential premises also. Because it is unjustified. You cannot say that only a landlord of residential premises can have a bona fide requirement and the landlord of commercial premises will not have any bona fide requirement. For example, if a businessman dies, leaving behind his widow and 2 children. Now, widow, she is not capable to continue that business. Children, they are too young to continue that business. So, for the time being, that premises has been given on rent. Now, after 20 years, when the children, they are grown up, now if that lady, that widow, now if she wants to get back the premises, if she wants to get back the vacant possession of the premises, can that be denied by saying that, look, you are the landlord of commercial premises, so you are not entitled to claim bona fide requirement ground because your requirement is not covered under these grounds. It's just arbitrary discrimination which has been created between a landlord of residential premises and a landlord of commercial premises. So it was held in Satyavati Sharma very clearly by the court that there is no justification. This discrimination is arbitrary. And it was held by the court that even a landlord of commercial premises is entitled to file eviction petition on the ground of bona fide requirement. And after this particular case, the courts, they were flooded with the litigation by the landlords of commercial premises. Because normally what happened, the legislature is not amending the law. The legislature is not changing the laws because a lot of pressure is being created on the legislature by the traders lobby of Delhi. By the traders lobby of Delhi, why the traders lobby of Delhi has created that kind of pressure on the legislature? Because it is the traders lobby of Delhi which are getting benefit of these kind of provisions which are tilted in favor of the tenant. It is the business persons or the tenants who are occupying places in top commercial places in Delhi, like in Chandni Chowk, in Lajpat Nagar, in Connaught Place, all places like top commercial places in Delhi. They have taken premises on rent. And by using that premises, they are earning crores and crores of rupees. And in return, what the landlord is getting? The landlord is getting that old rent which was fixed just 50 years back or 40 years back or 30 years back, like 500 rupees per month, 1000 rupees per month or 2000 rupees per month. It's very nominal rent the landlord is getting because of the protection which has been given to the tenant under the provisions of Delhi Rent Control Act. So that is why judiciary, in some cases, the judiciary on its own has declared some provisions of Delhi Rent Control Act as unconstitutional, and those provisions have been struck down by the court. In the very same part, another very important topic is Section 21, that is limited period tenancy. That you can say is a kind of exception to Section 14, because Section 14 says that landlord is bound to bring his case under the grounds which have been given under Section 14. Only after that he can file eviction petition. But limited period tenancy says that if you are having a premises which is lying vacant, you do not require that premises for a particular period, then you can create a limited period tenancy for that particular period. And once that period comes to an end, after that, you are not supposed to bring your case under the grounds given in Delhi Rent Control Act. You can, if the tenant is not vacating the premises, you can file an application straight away to the rent controller, and in return, the direction will be given to the tenant to vacate the premises. So this provision is an exception to the general law which has been given in section 14, and this has been inserted intentionally by the legislature for the purpose of giving a kind of incentive to the landlords who are not using their premises, whose premises is lying vacant, to give them an incentive that you are not using your premises, please give your premises on rent, and we assure you when your this limited period tenancy will come to an end, the vacant position of the premises will be given back to you. So this is an exception where limited period tenancy can be created by the landlord. Then this part 4. Part 4 of your syllabus, it deals with Slum Clearance Act. The Slum Clearance Act, again, it was enacted with the intention to protect the tenants from eviction, the tenants who are residing in the slum areas, and it was enacted with the intention to develop slum area. So if a property is situated in slum area, then entire power regarding that has been given to the competent authority, and unless or until permission is being given by the competent authority, no one can file eviction petition against the tenant. And even if landlord has got eviction order from any other court, if the landlord has got eviction order from rent controller under Delhi Rent Control Act, or if he has got eviction order from civil court, even then he will not be able to execute that order unless or until permission is being given by the competent authority under Slum Clearance Act. So some of the provisions of Slum Clearance Act we will discuss here under topic 4 with the help of cases which have been given here in your case material. And one very important aspect which also we will discuss here, that is what will happen if there is a conflict between Rent Control Act and Slum Clearance Act. Suppose a landlord files the eviction petition under Delhi Rent Control Act on the ground of bona fide requirement, but that property is situated in slum area. What will happen in that situation? Whether he is entitled to file eviction petition only on the after getting permission from rent controller, or he is required to take permission from competent authority. This is a very important and very complicated aspect which in detail I will discuss with the help of relevant cases here, that what will happen if there is a conflict between the two laws. There are various doctrines of interpretation which will be applied, and on that basis, ultimately the decision has been given by the Supreme Court in various cases which I will be discussing with you in my class. So this is in brief the overview regarding this particular subject, and I hope that I am able to make it clear that what kind of subject it is, what you are going to study under this particular subject, and what is the relevance of this particular subject. So if you are having any query or doubt, you can ask it.
Ma'am, basically, this rent control will deal with Delhi rent control only or other state also?
No, it will deal with Delhi rent control only, but it will help you to understand the rent laws of other state also, because rent laws in all the states almost it is similar with some difference. The major portion of rent control laws is similar in all states, but primarily we will be discussing Delhi Rent Control Act. But yes, we will be relating it with some other rent control acts also at some point, like with MP Rent Control Act, with Bombay Rent Control Act, that we'll do.
Ma'am, one more question. Ma'am, is this subject is related to LLM also? Will find some relation in LLM?
No, this subject you will not find in LLM. This subject is not there in LLM. So if you are thinking to take this subject as an optional subject and then pursue it in LLM, that you'll not get there. But otherwise, this subject will help you if you are intending to appear in competitive exams or you are intending to join the field of litigation.
All right, ma'am. Got it. Thank you, ma'am.
Anyone else? So over to Shivika.
Thank you, ma'am. Now I would request Dr. Gurpreet Singh to please throw some light on international trade law as an option subject.
Okay, thank you, Shivika. Am I audible?
Yes, sir, you're audible.
Okay, give me a minute. Let me share the presentation.
Indeed.
Okay, is it visible?
Yes, it is visible.
Okay, thank you. Uh, International trade law is another options in your fifth semester, which I am going to teach to you. You have already read the international law, which is compulsory in your second semester. International trade law is also part of the international law, but it is some kind of specialized kind of subject in which we are going to discuss international trade and commerce. So what it contains? What are the subject matters which we are going to discuss in international trade law? Basically, international trade law deals with the all international conventions, legislations, bilateral, multilateral treaties, international ecoterms, international organizations such as WTO. These all things from the part of international trade law. Though this subject is quite wide now, but we can't discuss all the aspect in this one semester. Therefore, we have carefully chosen only certain those topics which are of your interest. Uh, so international trade law is not a new thing. So you know that right from the advent of the Europeans in Asia and Africa, when they made Asia and Africa and Latin America as their colonies, and with the industrial revolutions, then there was a development of the mercantile laws in England, and those mercantile laws later on they developed and became the foundation stone of the for the modern trade law. Although there is also influence of Roman law and Germanic law in some certain respect. So international trade law, in international trade law, we are going to discuss certain international law which are regulating the international trade between the state, and among them the GATT and the WTO, which is going to cover the major portions. Now, what is the basic idea of international trade law in modern international trade law? Modern international trade law, developed after the Second World War because of the efforts which was made by the European countries to liberate the world market. So, modern international trade law is based on the free market economy. The economy which supports the free flow of the goods and services without any trade barriers or any kind of restrictions by the part of the state. So it contemplates the free market. The domestic market is to be left as open, and it must provide the access to all the countries of the world so that the state could come and trade without any kind of restrictions. A second most important principle of a modern international trade law is the principle of comparative advantage. Simply, the Ricardo theories, which we sometimes take as a basic basis of this kind of principle, is that if a state X is good in one particular goods and state Y is good in another particular goods, then they must exchange with each other, and by doing so the both countries are going to get the benefit. So it is a case of the mutual benefit of the both countries. And these liberalists who believe in the liberal trade economy, they believe that this international trade, modern liberal international trade, will sharpen some kind of competitions among the state. It will motivate the inventions. It will bring a lot of success for the states. So, modern international trade law advocates for the liberal trade policies worldwide. Uh, this is just an introductory part, and after that we will begin with the major part, which is going to cover in your syllabus. That is the GATT. GATT is the General Agreement of Tariffs and Trade, and this is significant because of from 1947 to 1994, the GATT was remained the prevalent kind of trade agreement among the states. In fact, if you will look at the GATT, if you will go into the history, GATT was accidental. The birth of the GATT was just an accidental reason there being that the European countries, when uh, United Nations came into existence, they wanted to make similar kind of organization, that was the ITO, International Trade Organizations. But this idea was never materialized. The reason they are being is that when the proposal for the ratification was sent to the US Congress, the US Congress denied to give the approval. So resultantly, ITO was never materialized. It did not see the day of light. And GATT, which was some kind of temporary arrangement at the time, it became some kind of a permanent kind of a setup right from the 1947 onward to till now, in fact. There is the difference that earlier GATT, it was only concerned with the goods, the trades in goods, not with the services. But in present, the GATT is not only confined to the services, but it also covers other area like intellectual property rights. So at present, the GATT has become one of the very large kind of area which covers different parts. Then 1994, under the GATT, what was the procedure? And in fact, under the GATT, the procedure was, which was adopted by that was through the conferences. Many trade conferences took place. These are sometimes known the negotiations rounds. In 1986 to 1994, in last round, that is known as a Uruguay round, this WTO came into existence. So WTO is one of the important international organizations at current, which is dealing with the international trade. And why it is very much important, you will look at the structure of the WTO, you will look at the principle of WTO, that will reveal that why WTO is very much important. Now, what is the basic idea behind the WTO? Yeah, what we can say that what are the basic provisions under the WTO? First, the WTO is based on the free trade. It advocates for the free trade among the state. Number two, it is based on the principle of non-discrimination. Principle of non-discrimination simply means that whenever the state will trade with each other, there would be no discrimination between the goods of the foreign country and the goods which is produced within the country, the domestic goods. There would be no any discriminations. There would be same policies. There would be same laws, and there would be same regulations for the national as well as the international trade. So there is two major principle of WTO. One is the principle of national treatment. National treatment principle is simply means that whatever the rule and regulation you have for your domestic goods, the same rule and regulation would be applied to the foreign goods when you import the foreign goods from the foreign countries. You would not treat them that differently. You have to treat them as if they are originated within your own country. Therefore, the principle of national treatment is again the principle of non-discriminations. Then another important principle which you can see here, the principle of most favored nations. Sometimes the people feel confused by this principle, that if this principle is conferred, then this status is conferred upon one state, it means the special treatment is going to be done with that country alone. That is not the case. Under the WTO, once the most favored nations status is conferred upon one state, it simply means that all the states which are the party to the WTO, they are going to be similarly treated. There would be no discriminations on the basis of MFN. On another word, it means this is principle for non-discriminations. It means whatever the relaxations, what are the conditions you have been laying down for one country, the same relaxation, same conditions are to be laid down for all the member state who are the part of the WTO. So these two are the major principle upon which the WTO is based, and these principles you will find in the different agreements of the WTO. Then subsidies and countervailing measure is the another important topic in your first part. Subsidies simply means that in order to promote some domestic industry, some or particularly in farmer sector, the subsidies is given by the state. But sometimes the subsidies by the part of one state may result in some kind of a harm or injury to the another state. Then in that situation, what would be the right of the another state? Then the agreement on subsidies and countermeasure provides that other state has a right to adopt the countervailing measures. Countervailing measures in order to counter the subsidy which is given by one state. So under this agreement, subsidies is also divided into three kinds, which you might have heard somewhere. Uh, that green box subsidies, yellow box subsidies, and red box subsidies. Green box, which is totally permissible under the agreement. Yellow box, which is permissible with certain conditions, and the red box subsidies, which is totally prohibited. So we will discuss these subsidies in detail when we deal with this topic. Then another important topic under the WTO is dumping and anti-dumping measures. So dumping means when a country is making a surplus production in certain goods, then generally those goods are dumped in the another country, meaning thereby to sell the goods below the market price. And the purpose behind dumping is to capture the market, so that once you will capture the market, you can establish your monopoly over that market. So that is known as a dumping. And sometimes you might have heard that China has dumped its goods in India. Then what would be the remedy which is available to the state where the dumping is done? Then in that case, the state has a remedy to adopt the anti-dumping measures. So what are the anti-dumping measures? How far the anti-dumping measure could be adopted? What would be the balance between the dumping and anti-dumping measures? That we are going to look at when we will discuss this dumping and anti-dumping measures in the topic. What is the structure of the WTO? This is one of the topic of your syllabus, structure of the WTO. If you look at the WTO, the ministerial conference is the apex body in the WTO, sometimes also known as a general conferences. So this apex body generally meets once in a 2 years. And what is the purpose of this ministerial conference is to make the rules and regulation and review the trade policies. Then under these general conference, there are other councils, the council which is concerned with the trade related aspects of intellectual property rights, IPR, then the council for the trade in service, council for the trade in goods. So all the three areas are being covered by the WTO. Beside that, what is the robust mechanism which we have today in the WTO, which is the different from the other bodies? That is the dispute settlement body. Under the dispute settlement body, there is a mechanism where we have set up the dispute settlement at the panel stage. The panel is constituted in order to solve a dispute among the parties if any dispute arises among them. If one party is not satisfied with the decision or the report of the panel, then another party has a right to go in appeal. So there is appellate body as well. So under the dispute settlement body, we have the appellate body and panel body which settle the dispute among the member states. So you might have also read in newspaper recently that dispute settlement body, the appellate body has become somehow defunct because of for a long time the members were not appointed. So numbers which are required to settle the dispute in the appeal, it became less. Only I think one member is left now. So it is a defunct body, and there is a lot of politics which is going on. The United States doesn't want, or United States wanted to change the structure of the dispute settlement body, and like when the Trump was there, he was not very much happy with the WTO. In fact. So a lot of politics is also going in the WTO that we will see when we will discuss this WTO. And after this, uh, what is the scope of the WTO? WTO is basically concerned with the framework for the administration and the implementation of the agreement among the parties who are the parties to the WTO. It is the forum for the negotiation and dispute settlement, as I have already made it clarify to you. Then the WTO also provides for the trade policy review mechanism. It promotes the greater coherence among the member uh, states. Then this is the first part. So first part is largely concerned about the WTO and these international trade agreements. In the second parts, we have the general part, which is going to cover international eco terms, which is known as international commercial terms. Of course, we can't discuss all the terms. Therefore, we have taken three specific terms. That is just to give you the ideas behind these terms. One is the CIF, the cost, insurance and freight. Another, free on board, free alongside ship. With the passage of time, these terms has been standardized. Whenever this term is used in a transaction, it has a certain meanings and implications. Reason there being that with the passage of time or with the expertise, these terms are often used during the uh, uh, during the transportation of the goods from one country to another country. Then, in order to have a certainty in the payment, again there are the certain terms: bill of exchange, letter of credit, and bill of lading. The significance of these terms is that these terms have certain meanings. These terms have certain implications in international trade law. Wherever these terms are used, it generates certain rights and the liability of a buyer and sellers. That how many parties are involved, what are the rights of buyers, what are the rights of the sellers, what are the significance of these terms, we are going to discuss in the part 2. So part 2 covers the general aspect of international trade law, particularly the international trade contract. uh, then carries of the goods by the sea. The what do you mean by a bill of lading? How many kinds are the bill of lading? What do you mean by the chartered parties? What are the rights and what are the duties of the parties therein? So that we are going to discuss in the second part of the international trade law. So this is your syllabus which we are going to cover. International trade law is very important subject because of when you are living in a globalized world, particularly. Uh, I used to give the example to the student that whenever you will go to the mall, you will find a multi of the brands now, which were not earlier available. Now you can go to mall, you can buy any brand of any country. So how it is possible? This international trade law, the modern international trade law, it has brought the whole world together. And trade was the real reasons that which was result in the colonialization of the African or Asians or Latin American countries because of the European countries. They wanted to sell their product in these countries. They wanted to bring the rich resources or exploit the rich resources of these countries. Therefore, these colonies were made the one of the biggest source for the prosperity of the Europe for a long time. Therefore, international trade law is very much important kind of a subject to study. Or if you will look at that, there is a lot of opportunity. You can be an international trade lawyer. You can go to the international firm which is dealing with the trade and policy. You can also help in uh, uh, Ministry of the Commerce, Trade and Commerce, which is looking for the trade. So even if you want to do the LLM, many European countries, they offer specialized course in international trade law. You can look at in the website of the university. You will find that they are offering the specialized course in international trade law. It means that this subject has a significance. So that's all from my side. Thank you very much. And if you want to ask something, you may. Okay, over to Shivika.
Sir, can I ask something?
हाँ जी, बोलो.
Sir, this is majorly a conceptual subject, or there will be case laws also involved into it?
Yeah, there are many case law involved actually. If you look at the syllabus which is available on the website, you just go there. There are so many cases which we are going to discuss under the separate headings. Like when we were discuss the most favored nations principle, or when we were discuss the national treatment principle, of course discussion of on these principle would not be complete unless we discuss the important case law. So there are many case law which we are going to discuss. I have just given you the brief idea. When we will discuss, we must discuss this case law. But,
Right, sir.
actually the concept are developed through the case law.
Thank
That's
you
why
very much, sir.
appellate body and panel body is there. Hanji. Anything else?
No, sir. Thank you.
Thank you, Ji.
Thank you, sir, for dealing with different facets of international trade law. I now request Dr. Avikta Verma, Associate Professor at Law Center 1, to give an overview of criminology as an option in the fifth term.
Thank you.
Thank you,
Welcome, sir.
Shivika. Well, I would like to share the screen. Just give me some time. Okay, so I think it's visible now.
Yes, ma'am, we can see the screen.
Okay. Well, before I begin, I just want to give you all good news that I'll be the last speaker. So I hope all of you are not tired as such, right? And I hope I'm getting the most serious and discerning audience now in the end, right? Who are really want to know about what are the subjects which are to be offered. So thanks for being there till the end. Now, as I know that you will be, you have to make this choice in the next semester. So all of us know that you have already done or studied IPC, law of evidence, and the other one is the CRPC, right? The triology of criminal law. All of you have already done. And so I do believe that all of you are experts in this particular field. So when you did all these subjects, right, when you read...
Avikta, ma'am, I would just like to request you, somehow the screen isn't visible. Could you please share it again?
Yeah. I'll be sharing. So I had, because I wanted it to be an interactive session. So I just wanted to know who are the students who are responding. So maybe that's the reason, you're not seeing the screen. I'll make it visible again. So as I know that you have studied all these three subjects, and when you were, and you have a fair idea of what criminal law is in the country. So, and you do always, as you open the newspaper, as you hear the news, you do hear about crime. It's such an everyday reality. So what is the impression you have got overall, or what are your concerns, or what were your thoughts that came to your mind, through this journey when you were doing these courses, IPC, CRPC, evidence, and some of you must have done some internship also with some criminal lawyer, or just visited court, किसी तरह की internship भी आपने की होगी. So are there any of your concerns, any of your observations, any of your thoughts? What does it make you think? And we see the media always sensationalize everything. So what thoughts come to your mind? Yes, anyone? Okay, as I get one response, Mr. Ramesh is saying the major concern is reduce crime in society. Right, others, you can unmute yourself and communicate. You have been listening throughout, so Just speak up. That's what all the lawyers do. Yes, anyone else?
Yes, ma'am. Basically, this one only, because we have, ma'am, law of crime 1, law of crime 2, and law of crime 3. That is white collar crime, which is
Okay.
deals with narcotics also,
Yes.
right, ma'am? So
Okay.
basically, criminology, I think it will deal with this key, how to reduce such type of crimes in society, which is
Okay.
happening.
Okay, but what are your concerns? We will discuss about what the criminology is all about later. But when you did IPC, you did Evidence Act, you did CRPC. They are such wonderful subjects, and quite interrelated. IPC tells you about which acts are crimes, and then CRPC generally gives life to IPC. ठीक है, क्राइम हो गया तो उसके बाद आपको कहाँ जाना है? अगर वो चीज़ नहीं होती तो then it's useless, right? It tells you about the forum. It gives life to IPC, and it gives life to IPC only because there is law of evidence. The whole thing, how the crime will get proved. So there is this triology of law which makes a full circle as far as criminal law is concerned. So when you were reading all these laws, you were doing case laws, and in the meantime you keep on hearing about news about crime and all. So what are your major thoughts? What are your major concerns? It must be making you think something.
Yes, ma'am. My major concern is that, ma'am, one more point I would like to add. That is
Okay.
how, because some people have taken up a wrong way, right, ma'am?
Okay.
How to bring back to the society and
Okay.
make them to be a good citizen and work towards the government for making the welfare state, basically.
Okay, very good. Wonderful thoughts. Anybody else would like to share? बाकी लोग क्या सोचते हैं?
Ma'am, keeping myself very opposite to what we are discussing. I mean, keeping the since we are going to be discussing about criminology and various theories of punishment, which are going to be there, which we will be studying, and I think when I my preliminary observation is our criminal justice delivery system is highly lopsided. I mean, given the inordinate pendency, delays, and poor coordination between prosecution, police, and the interplay between the own play of defense lawyers and how they sort of instead of becoming a savior to the accused, they sort of they try to manipulate the entire process for their own benefit. They just want to make money out of the system, and that's how, I mean, this is to talk about the criminal side of how things are. We say that in India we follow reformative theory of punishment, but I don't, in practicality, keeping in view the circumstances and all those things, I find it more sort of a vengeance that the state is you know uh, putting on the person, the accused. That's what my preliminary object this thing is, observation is. Even before getting convicted, the whole process itself is a punishment.
Okay, very insightful observations. Anybody else has to say something? No. Okay, so we proceed further. So the concerns which you have raised, they are quite very much genuine, basically. And when we talk of criminology, it deals with all these kind of concerns, right? When we look at it as a subject, right, if which we will be doing, so it basically is a systematic study of crime in all its aspects. Like one of you raised this concern, like wondering about why some people commit crime and how they can be rehabilitated. So criminology does look at the causes of crime, right? To what extent they have an impact on the society and what can be done about these people. So when you have these laws, IPC, law of evidence, you have CRPC, why in the first place we have all these laws? The jurisprudence behind these laws, this is everything about criminal jurisprudence, right? The way why you have recognized this crime of that is adultery, then why it got in a way de-recognized, right? Why homosexuality, it was a crime earlier, that not later on? What are the factors that go beyond it? So क्यों हम कुछ एक्ट्स को क्राइम रिकग्नाइज करते हैं, क्यों कुछ एक्ट्स को हम क्राइम नहीं रिकग्नाइज करते हैं? एक एक्ट के लिए कुछ पनिशमेंट है, for other act there is some other punishment. Why there is variation in punishment? And now the law, I mean, recently the legislature has passed the different legislations, for example, and brought out the amendments also. For example, Juvenile Justice Act was amended. What was the need to amend it, right? So, and recently only this criminal reforms committee was constituted. So criminologists do play a great role in all this. Fine. So here we just do not discuss ki, okay, I feel this is right, I feel this is wrong, I feel this is how the thing should be. Here we look at it in a scientific manner, right? Basically, criminology is a scientific study of crime. It simply just goes beyond thinking about crime. It is about researching the causes, right? Researching about the impact and the possible solutions. So all these questions: why do people commit crime? Why in some circumstances or environment there is more crime, right? Is it does race, culture, gender, age something to do about it, right? For example, in today's scenario, presently, if we see traditional crimes, when the lockdown was imposed, traditional crimes got reduced, but cyber crime increased. More than 300% increase was there, and all those traditional crimes have also moved in the, you can say, online domain. तो वो भी जैसे theft है, और भी बाकी चीजें हैं, stalking है, or whether trafficking है, all this has also now shifted online. So now, why the crime reduced during that time? Does space, does our designing of the cities, all those kind of things also has an impact. So criminologists started looking at those aspects also during that time, right? So everything, all these queries, concerns which you raised, one behavior is crime, other is not, how to explain it, how to respond to it, whether we should have a rehabilitatory approach, when to have a reformative approach. So all that is taken care of in this particular subject, right? We do have in criminology, first of all, if you see the syllabus, the first part is we deal with the schools of criminology, the theories and all, but then it is not also boring. It is, when we discuss about schools, we discuss about contribution by different thinkers, theorists who were really wonderful people, very courageous people. And like as youngsters, you are also thinking about why crime happens, what kind of approach it should be there. The criminal justice is like that, right? I as a criminology teacher also think about these things. But then when we discuss schools, you will come across the lives of these young people, right, who in their young age, they simply did not even think about crime and all these issues or problems. They researched, they contributed, right? Even to the extent that they knew that there will be a threat to their lives, to their positions in lives, but still they had good ideas, and they gave fruition to those ideas. They implemented those ideas. They brought them into public limelight, and at times they did it anonymously. But this, they did it, some of them at a very young age, in their 20s only, and you can see their good ideas that had impact all over the world. Right, it traveled as far as US, where the Constitution of the US, the Bill of Rights, the 14th Amendment, everything was impacted. So it's not criminologist is just confined to study about crime. It's about the whole kind of system we'll be having in a country, and it has a very great impact. It shows in different other policies also. So the criminal law, how it got shaped in the West, right, the kind of ideologies they adopted, and how it impacted the lives of the people there. The impact was so great that right from the 17th or 18th century to the 20th century, or even in the 21st century, we can see its impact. And how, what the criminologists say, that is even taken care of by the policymakers. So how criminologists, these different school of thoughts, they have made the life of the people better all over the world. And also we are also you can say taking advantage of all that. We have also been benefited, because whatever the system we have got, IPC, CRPC, evidence, it's all just given to us by the Britishers. ऐसा नहीं है कि हमने कुछ ज़्यादा कुछ create कर लिया है, but we have the capability to do it, to create it. So when you study criminology, what is desired is that you study it with a very open mind, with a very critical mind, with a very analytical mind, right? So that whatever knowledge you are gaining, you are able to connect it with the present reality and really understand how these schools, they are not just boring theories. They're wonderful people who have given these theories. So if you know about their lives, their contributions, how it has impacted the present system, you will learn very well, and you'll be able to apply that knowledge. And that if you do it in that way, that knowledge will stay with you forever. Whether you become a judge, whether you become a lawyer, whether you become a public prosecutor, or even as a citizen, right? So it is going to be with you, and it will be helpful in taking decisions or in contributing. So when you have your law commission reports or different committees being set up by the government, they put these things in the public domain, that if you have anything to contribute, so they welcome that, whether it's Ministry of Women and Child Welfare, whether it's Ministry of Law and Justice. They do ask for suggestions from the citizens. So as student of law, as criminologists, right, or a student of criminology, you can always imbibe this knowledge, analyze this knowledge, apply this knowledge, and contribute in making things better. So as a part of criminology, it's not simply about the schools and the theories, which do look at the causes and other aspects, but we do discuss penology, which is mainly about the study of punishment or similar methods of dealing with the crime. Right? Should there be capital punishment? What should there be life imprisonment, rigorous imprisonment, simple imprisonment? How the different combinations are to be worked out? Why these punishments are there in the first place? Then also we deal with victimology, right, which is a scientific study of crime victims. So what is the impact of the crime on the victims? What are the type of victims? What are the laws which are there dealing with it? And there are so many other things. Okay, when we look at the reformative aspect and all, we do look at probation, parole as measures which are taken for the you can say later on rehabilitation or resocialization of the accused into society. So these are the different things which we will be discussing. And when we look at criminology as a career option, it has great career options in the sense, if you want to be a lawyer, and especially criminal law practice, if somebody has to do, then this is something which is very important. It gives you great insights into different aspects, right, of crime causation, or even what kind of a responses need to be there when you have to form your arguments. Because when you present the case, it's not only at the stage of the trial, at this time of the sentencing, what are the, because the court does look at the mitigating and the aggravating circumstance. So unless and until you have a good knowledge of criminology, the level of arguments, the kind of arguments that we will be presenting, the quality suffers. Then as a judge, also it's important, because as a judge you have a discretion what kind of a sentence you give. When we discuss juvenile justice system, we discuss many aspects of it. So as a judge, when you have to the judge has a wide sentencing discretion. I mean, juveniles are generally not sentenced, sent to prison, but then how creative you are, right? So what kind of a task or responsibility you give to the juvenile, so that you are able to achieve both the things, reformation as well as realization on the part of the juvenile that he or she has done something wrong. So criminology, because it requires an analytical mind, it requires a critical mind, it requires you to be creative, right? So it gives you those scenarios whereby you can approach this subject in this way, and later on also apply your knowledge in that way, right? You may come out with the, you can say, wonderful solutions to the existing problems. There is no limit to it, right? We need good thinkers, and criminologists have always come forward and helped in making society better, making laws better over a period of time. Then as a policy maker, you can make your contributions. Fine, government need those kind of people who can give these better insights. Then forensic sciences and other aspects. There are so many, for example, recently there was this National Forensic Science Lab, Science University, established in Gujarat. Or otherwise also we have forensic departments, then you have criminology departments in universities, you have different police training institutions and colleges where criminology is one of the subject area, right? So there these experts are required. And if you want to enter into academics, then definitely criminology as a subject is there. And then those universities which generally focus on MA in criminology, etc. So there they require teachers who are specialists in this area. And there is a net apart from law, separately for criminology as a subject also, it's there, one of the qualifications or criteria which is there. And you can also work as an independent researcher, right? And somebody who wants to basically pursue further studies in this, then UK is the best destination, where a lot of research is going on in this area, and they do make a lot of contribution. They have special chairs also in university for this particular subject. So I hope I have given you a brief overview of the subject, what all you can expect to study in this particular area. So if you have any questions, any queries, so let me know.
Ma'am, I have seen the syllabus of this. There is something mentioned about prison reforms.
Yes.
What is relevant to this case, this topic,
Yeah,
criminology?
it's very much relevant because the whole story starts with, if we talk about crime, IPC, right? Some act done, some crime happens. Then next comes your CRPC and evidence. IPC defines crime and also provides the punishment for the same. And punishment, वो क्राइम क्यों रिकग्नाइज किया है उसके पीछे क्रिमिनोलॉजी है, उसके लिए क्या पनिशमेंट दी है उसके पीछे क्रिमिनोलॉजी है. Once a person is convicted and a sentence is given, the person is sent to prison. Fine. Legislature ने law बनाया with a particular objective, but then in the realization of this objective, there are so many people who are involved, right from the police, then the judge, lawyer, and then the prison. Prison में person पहुंच गया, उसको वो punishment मिली. Now whether it's simple imprisonment, rigorous imprisonment, how many years, whatever it is given by the judge with a particular you can say objective. Right. Sometimes you will see when a judge is sentencing, he's saying for deterrence. Sometimes he's clearly mentioning in his judgment for reformation. Now, once the person goes to the prison, whether the objective with which the sentence was given, that is realized or not, it all depends on the conditions in prisons, the treatment given by the prison officials. So if they fail, then everything comes to a zero. Instead of being reformed, the person will become a hardened criminal. So how you need to deal with the prisoner, whether it's a woman, whether it's a young person, whether it's a habitual criminal. So everybody, it is individualized treatment is something which is desirable. So what happens in prison ultimately also is going to have a impact on whether the real objectives are realized or not. So if your prisons are overcrowded, right, if the treatment given is not good, if there is discrimination, if there is corruption, तो सारा पर्पस ही जो है वो डिफीट हो जाता है. So prison is very important. What is happening in prisons is very important, right? And what kind of prisons we need to have. There are different types of prisons. So there's a different philosophy. So we'll discuss all in that. So we are focusing in criminology very much on police reforms as well as prison reforms, because the whole thing starts with the police. So how independent your police is, how professional your police is, how impartial and how fair your police is and competent is, that ultimately decides. If you look at the NCRB data, in heinous crimes, our conviction rate is very low, only 4%. And those of you, if you remember what you read in your CRPC, right in the first case, Lalita Kumari case, you may recall, in that only Supreme Court had stated 50% of the cases, if you are seeing that they are getting registered about a particular offense, then 50% are not registered. There is a dark figure of crime. So criminology deals with all these aspects.
राइट मैम मैम वन मोर क्वेश्चन मैम मैम इसके अंदर एक टॉपिक वो पुलिस रिफॉर्म का भी है, तो एक पॉइंट ये पूछना है, पुलिस रिफॉर्म जो है वो सब्जेक्ट मैटर है, बट सब्सिक्वेंटली जैसे सीबीआई है, एनआईए है और स्पेशल एजेंसीज जो गवर्नमेंट ने बना रखी है, तो वो भी इसी में आएगा, इसी टॉपिक में, या वो अलग होगा?
हाँ, पुलिस रिफॉर्म्स मीन्स ओवरऑल, with respect to all, whether it's special agencies, whether it's police, though we specifically focus on the state police, right? And but still, because ultimately jitne bhi higher officials hote hain, even the state mein, so they are the central government officers basically, right? And तो central cadre से ही belong करते हैं. So ultimately we are focusing, we are looking at a broader picture.
Okay ma'am, got it. Thank you ma'am.
Okay. So any other question? No. So okay, fine. So thank you, Shivika. So over to you.
Thank you, ma'am, for the engaging interaction, highlighting the various objectives of the course. Having had this very engaging discussion, we come to end of today's webinar. Thank you to all the resource persons for providing different aspects, future implications of the subjects, along with an overview of the subjects. And now we proceed to the vote of thanks. Again, wishing our revered Professor in charge, Professor Dr. Sarbjit Kaur, ma'am, learned resource persons, our wonderful students, and my worthy colleagues, a splendid evening. I, Shivika Choudhary, in my capacity as Program Director for the webinar, on behalf of Law Center 1, extend a very hearty vote of thanks to all of you for making time from your commitments to participate in the webinar on subject orientation for overview of optional subjects for LL.B. fifth term. We place on record our utmost gratitude to our Professor in charge, Professor Dr. Sarbjit Kaur, for being the catalyst that stimulates us to do our best and standing as pillar of strength. Ma'am has been a constant support to all the activities at Law Center 1. Ma'am's many endeavors in making education inclusive and interactive, and her genuine concern for the students is truly appreciable. I express my sincere gratitude to our resource persons who spared time to present at this webinar. Today, we have had an opportunity to hear your thoughts on the various optional subjects, and certainly this will provide much needed clarity to the students. While discussing intellectual property rights law, second, Dr. Sunanda Bharti brought to the forum her years of experience at teaching of the subject. Dr. Avekta Verma's engaging interaction on criminology would certainly inspire students to take up the subject. Dr. Amrendra Ajit provided a detailed subject overview on jurisprudence second. Dr. Anju Sinha introduced the upcoming topic of concern, that is rent control and slum clearance, and provided practical implications of the same. The students were greatly benefited by Dr. Parveen's presentation on business regulations. Information technology law was dealt in detail by Mr. Anil Sain. Lastly, Dr. Gurpreet Singh presented with great clarity the challenging subject of international trade law. It was a wonderful interaction for the students to learn about the contents of the various subjects, what expectations they should have from the subjects, how it would help them in future, does it align with their career goals? And in knowing answers to all these questions, the students would be in a position to make a rational, well-informed choice of the subject option. With a deep sense of appreciation, I thank my colleague, Dr. Anju Sinha, who in her capacity as Program Director made remarkable contribution in organizing the webinar and for being so very supportive throughout the planning and execution. I also extend my sincere thanks to Mr. Pushkar Anil for uploading the details on the website. Last but not the least, a big thank you to each one of you who made it to this webinar. Once again, I want to remind the students that on the poster that was uploaded on the website, there is the link of the subject option form. Please fill that link, and the subject option form will be available from 7 p.m. It's already available as of now on from today to 5 p.m. on Monday of August 16. And with this, may you all leave more enlightened and better equipped to make a responsible choice in selecting subject option. Stay blessed and stay healthy. Thank you so very much.